SJC-13465, in the matter of an impounded case.
Okay, attorney, carry on whenever you're ready.
Good morning, Your Honors. May it please the court, my name is Pauline Curian, and I represent the petitioner in this matter, which poses the question as to whether the Juvenile Record Sealing Statute, Chapter 276, Section 100B, applies to the sealing of juvenile court youthful offender records rather than the adult criminal record sealing statute. The Commissioner's present application of the adult sealing statute to youthful offender offenses not only puts children in the hopeless situation of having lifetime never sealable records, and also poses longer waiting periods at a critical time in their lives when they might be entering the workforce or pursuing higher education of some kind. But more importantly, the Commissioner's action in applying the adult statute flies in the face of the decision of this court and the legislature's action in creating a separate juvenile justice system apart from the criminal justice system.
Would you agree that really 100A and 100B don't answer the question, that we need to sort of dig into Chapter 119, Section 53 and Section 60 and see which one of those two is most applicable?
Well, I think that there is some language, for example, in Section 100A that uses the terminology criminal court and criminal court appearance or disposition. And so I think there, in terms of excluding youthful offender offenses from Section 100A, I think from the perspective of the appellant, that language can be helpful, though obviously—
Doesn't B say delinquency?
Yes.
Yeah, I mean, it's a problem. I think something clearly the legislature didn't contemplate.
Sort of a jump ball, maybe go to the other two?
Well, I think, I'll jump further into the argument as to Section 60A, which I think—
It's a question. It's not an answer, honestly. It's not an answer. It's a question. The question is whether 276, whether 100A and 100C really considering the period of time when the youthful offender statute passed, comparison to when 100A and 100B passed, if we're really, we really don't know. And Section 53 broadly protects juveniles, and Section 60A seems to say, wait a minute, interpret youthful offender records sort of like adults, and what's the interaction between those two might be more helpful in trying to get this right.
Well, I can specifically address the interaction between Section 60A and Section 53, but I would note that in Commonwealth versus Gavin, this court specifically referred to the fact that Section 100C pertained to the criminal court and therefore was not applicable to juveniles who wanted to seal records immediately after a positive disposition. But jumping to Section 60A, first of all, there is no language whatsoever in Section 60A of Chapter 119 that says anything about criminal record sealing. And there's no legislative history that indicates the legislature ever intended to deal with criminal record sealing when it passed the statute. Moreover, in terms of, if you look at the exact wording of the language in Section 60A, it doesn't lend itself, when you read it for the first time, to even have you think about that it might apply to criminal record sealing. When it was enacted in 1938, this was before the advent of computers and other technology, the function of 60A was to prohibit the public from publicly inspecting any court records that had to do with juvenile offenses. So when the legislature amended the statute in 1996, what it did was it continued the same function of prohibiting access to to delinquency records, but it carved out a special exception for youthful offender records. But it didn't do anything in terms of changing changing when or how these juvenile records, in terms of youthful offenders, would be sealed. And it's notable that at the time that the legislature amended Section 60A, we had a criminal record sealing statute for adults. We had a juvenile record sealing for adults. So more naturally, if the legislature had wanted youthful offenders to be more severely punished in terms of record sealing, there would be plain language and an amendment to the juvenile sealing statute saying you exclude youthful offenders.
It works the other way too, though, right?
Well, I think in this case,
Had the legislature, that argument, right, had the legislature want to protect YOs, they would have mentioned them in the.
right. Well, I think you have to, I think
That's why this case is so hard. And what we're looking at as well is, when you look at the YO scheme, some of it is juvenile protection and some of it is adult. And we have to kind of navigate to see, is it more like an adult prosecution, or is it more like a delinquency proceeding? And I don't know.
Well, I think obviously.
And I think you both make good arguments, and that's why it's a tough case.
Well, I think with youthful offenders, they are still children. And if the legislature had wanted youthful offenders to be punished in the identical way as adults, it would have simply put them under the jurisdiction of the adult criminal court rather than keeping them within.
But they get jury trials, they public access, there's lots of things, and they can go to state prison.
Well, that's true, but it's also notable that the legislature was very specific about it. What all Section 60A did was open the court files to public inspection. There was another provision that also was enacted that opened up the courtroom proceedings, but that's a far cry from having anything to do with criminal record sealing. And the function of 60A is different because what it does is it deals with public inspection of the records. And when you get to criminal record sealing, that's a separate stage of the proceeding. And as this court noted in Commonwealth versus Pond, once you get to the stage of sealing, the public has already had access to the trial, the media had access to the proceedings, and we're at a different juncture. And even cases with a lot of publicity at the time, the public interest fades very, very quickly. So in this instance, as the U.S. Supreme Court said, children are not miniature adults. So I think the use of Section 60A in terms of having it apply to record sealing really undermines the goals of the juvenile justice system. And the goal of the juvenile justice system is to rehabilitate children and provide those opportunities.
But there's also a goal of whether something is sealed or not. And again, this is a hard case, and you may be right. And Section 53 may be dispositive in your favor. It may well be dispositive in your favor, but 60 thematically recognizes youthful offender cases are different, and somebody who has an adjudication as a youthful offender, that might be, because of the seriousness of the crime, might be something that an employee ought to know, that a municipality ought to know before somebody's a coach, that there may be circumstances for that serious a crime that make it different.
Well, I think that the fact that the proceedings were open doesn't convey any clear intent to affect criminal record sealing, and the mandate of Section 53, which applies to interpretation of Section 60A, says that as far as practicable, children are not to be treated as criminals, but are to be treated as children in need of aid and guidance and encouragement. So obviously, you know, using Section 60A to bar the sealing of criminal records permanently for children or delaying their sealing isn't something that advances the interest of children or in any way advances the notion of rehabilitation. And Section 53 in particular has a second sentence that says specifically that juvenile proceedings are not criminal proceedings. Just as this court has said on many occasions in the Connor case or in Commonwealth versus Dones, children are not labeled as criminals, and the proceedings, even for youthful offenders, are not criminal proceedings. So in terms of Section 60A, it talks about a criminal court case, but how can you have a record that's equivalent to an adult criminal record when the proceeding isn't criminal? To have a criminal proceeding, a criminal proceeding obviously would entail a criminal record, but here these are not criminal proceedings. So there's no criminal record, and there's no criminal case because it's a juvenile case, and the legislature specifically has chosen to leave youthful offenders, in the juvenile court. Under the old system, when children were transferred to the Superior Court, obviously, their records then were treated the same way under Section 100A. But in this instance, we don't have any indication that the legislature ever meant to do that. So that the Office of the Commissioner of Probation basically fails to demonstrate the requisite legislative intent that the adult sealing statute would apply to juveniles in this situation. So any ambiguity is read in favor of the juvenile in terms of application of Section 53. And in terms of the broader picture in terms of criminal record sealing, as amici point out, in particular, the children who tend to be involved in juvenile court proceedings and youthful offender proceedings in particular tend to be Black and Latino and Hispanic. So clearly there are racial disparities. So if you go down this road and you start treating youthful offender records as adult records that are never sealable, what you're doing is exasperating the racial disparities that exist within the juvenile justice system and in the criminal justice system at large. And then the other factor that this court has to consider is its own opinion in Giachenko. This court, as well as the U.S. Supreme Court, have recognized that children are less culpable for their offenses than adults because of all of the science and the advancements made in terms of understanding brain development and child development in general. And then finally, I would also add that one also has to consider sort of the Pandora's box or the tsunami of collateral consequences that could result from a decision of this court that said that for sealing purposes, a youthful offender record is tantamount to either an adult conviction or an adult record. Because if you look at what happens with the interplay with Chapter 151B, Paragraph 9 in Section 4 specifically prohibits questions about cases unless there was a criminal conviction. So if we go down this road and we open up youthful offender records to a classification where they're equivalent to an adult criminal case, then that means a lot of those protections would be lost. The same with the immigration area of law. There are no opinions yet on whether a youthful offender adjudication is an adult case or it's equivalent to a conviction. So it could open up a loss of rights for for children at large that go well beyond the particulars in this case. And the last thing I would add, it's also of importance that the Commissioner of Probation's own legal counsel years ago issued a publication indicating that the Section 100B applied both to youthful offenders and to delinquency cases, and they both had a 3-year waiting period. So clearly there's ambiguity in terms of the statute, and even the legal counsel for the Commissioner of Probation doesn't know how to interpret it. And then there is, it's unclear how long that the Commissioner of Probation has engaged in this practice, even though they say it's long-standing. That doesn't appear to be the case in terms of practitioners who are out there who do record sealing. So in this instance, I would urge the court to find that Section 100B applies to the petitioner in this case and to issue a ruling that clarifies Section 100B applies to all youthful offender cases.
Okay, thank you very much. Attorney Pomponio.
Good morning. May it please the court, Nina Pomponio on behalf of the Office of Commissioner of Probation within the Massachusetts Probation Service. When the Office of the Commissioner of Probation, or OCP, sought to operationalize the intent of the legislature with the 2 administrative sealing statutes, one for criminal court appearances and the other for delinquency court appearances, it looked to Chapter 119.
You're in a rock and a hard place, we get it.
Yes.
Right? So, what about the fact that these are remedial statutes and that we should err towards the sealing part of it because of that aspect of it, and that would be the tipping point because of the nature of the statute we have here?
Well, I'd like to say from the outset that the Office of Commissioner of Probation does welcome this court's guidance on how to interpret these statutes. However, when we looked to these statutes, we saw a very direct instruction in 11960A. It stated that the records of youthful offender proceedings shall be treated like the records of adult criminal court records. So this seemed like a very direct indication, especially given the timing of this amendment. So when the legislature carved out the exception for youthful offenders, carved out that exception for our most serious crimes, it then amended 11960A to add the section that the youthful offender proceedings shall be open to the public inspection in the same manner and to the same extent as adult criminal court records.
So 68 took something that was ambiguous into you, crystallize it to make it an adult.
It gave us the best indication of the legislature's intent, in our opinion, because at the time of this amendment, the 2 sealing statutes existed.
I don't know if there's any legislative intent to glean because it's silent. I don't think there's an ambiguity. I just think it's just not addressed.
You're absolutely correct, Your Honor. Of course, we had to operationalize it, correct? You know, we were receiving petitions to seal youth for offender records. So this seemed like the best indication where the 2 sealing statutes existed, criminal court appearances, delinquency court appearances, and then we have 11960A amended to say, treat it like criminal court records. That, to us, seemed like the best indication we should treat the sealing like criminal court records.
I agree with you, this is difficult and everything, but don't you have to fold into the analysis Section 53?
Absolutely, Your Honor. We do not take the position that that youthful offender proceedings are criminal proceedings for all purposes and in all manners. What we are saying is that we are treating the records of these proceedings similarly to how we treat the records of criminal court proceedings. We do this because, again, of 11960A. We could not, of course, take the position that they are criminal proceedings. As this court has pointed out already with my sister's argument, 100A speaks to dispositions, not convictions. It never says the word adult. So we really are looking at a criminal court appearance versus a delinquency court appearance. As this court had pointed out, a youthful offender is neither. So where is the best indication of where we might put these? And given that 11960A was amended with the knowledge of these two options, it seemed like the best place to put them.
Are you arguing that that's how we should look at it?
Again, we welcome the interpretation of this court. I think we're here today to articulate why our position was rational at the time, where we were stuck between a rock and a hard place as this argument started. We tried to take a rational interpretation. So again, we welcome the opinion of the court, but we're here to merely defend that this wasn't an arbitrary distinction. It wasn't, as my sister seems to indicate, a intent to harbor children with records forever. I don't agree with all of the characterizations my sister makes of these records. I think it muddies the waters quite a bit. As we know, as we explained in our brief, the record system is incredibly complex in Massachusetts, and anytime we're talking about access to a record, it's going to matter who is asking, when they're asking, and what record, which I'm happy to discuss more if this court would like me to. We also don't disagree that there's a number of strong policy arguments in favor of placing youthful offender records within the 100B system for delinquency court appearances. Again, OCP sought to effectuate the intent of the legislature as best it could when there was no clear instruction. And our purpose, the probation's purpose, is not to insert our own policy judgments on top of that of the legislature's or this
I think
court.
that the numbers that council gave, and I don't know if I think it was in her brief, said that like the 14 cases, there's not a lot of these cases that occur, the YOs.
I do not have a statistic on how many occur. I don't believe we actually break them down in that way. When I think
I guess the next question I have is, how often does this come up for you folks?
we don't break down our ceilings in that way. I can tell you how many things we've sealed under 100B and how many things we've sealed under 100A, but I don't think I could tell you. I don't think we've broken them down further than that over the years. We do seal approximately 55,000 charges a year.
Because if we ask the legislature to act on this, which I think you could probably anticipate is going to happen one way or the other, I'm just wondering how many cases are affected, but you don't have that information.
I don't have that specific number. What might be helpful to know is that there are youthful offender records kind of fall in a middle ground of protections between delinquency records and adult criminal records. So with youthful offender records, they are, their court files are public under 11960A. The court proceedings are public under 11960A. However, they do not appear on the CORI, the criminal offender record information, which is maintained by DCJS. And they do not appear on that CORI based upon a 2018 amendment, the Criminal Justice Reform Act. And that's whether or not they're sealed. They're not going to appear on that CORI. And the CORI is the thing that a person would get when there's a background check.
I just heard that we have another YO case I think on Wednesday that talks about the numbers, so that's what I was confused.
Oh, you were looking at that. I didn't recall any numbers from any of our filings.
Yeah, that's what I confused.
I'm curious where they got those numbers. The CARI, on the other hand, the criminal activity record information, which is maintained by probation, the youthful offender record will stay on there whether or not it's sealed as well. So really what we're talking about is the court file. Because again, the CARI includes sealed records because it's for the use only for the courts and law enforcement. The CORI never contains youthful offender records based upon that 2018 change to the statute. So really what we're talking about is the court file and whether it remains public or is subject to that sealing time periods as stated in 100.
That's why you're saying 60A has the most application?
It's another reason why. I mean, of course, that change was made in 2018, but it's another reason why.
Let me see if I can understand why it might not apply, 60A. It doesn't say anything about sealing, and when it talks about the records of youthful offender proceedings conducted pursuant to an indictment shall be open to the public inspection, same manner as criminal. Well, the criminal record open to the public, but if it's sealed, it isn't.
But it's sealed under 276-100A for criminal court appearances. So what we're saying is youthful offender proceedings would then therefore be sealed under 100A for criminal court appearances. So it's not that it's never sealed. I think my sister might have stated never sealed, but what she's referring to is this particular offender has a number of charges for intimidation of a witness. And under 276-100A, the criminal court appearance statute, there are specific offense restrictions that are never sealable. One of them, in fact, is intimidation of a witness. Those same offense restrictions do not appear under 100A. So that's why to this particular petitioner, this matters quite a bit, because that sealing would only apply if his youthful offender proceeding was treated as a delinquency court appearance. But again, I put into context that we are talking about the court file because it wouldn't appear on that query regardless. Another thing that my sister brought up that I thought was important to indicate is that the appeals court in JJ had previously determined that because 100C, the discretionary sealing statute for non-convictions, uses the word conviction, that juvenile delinquency proceedings did not fall under that statute, meaning that juveniles always have to wait the 3 years under 100B to get sealing, whether or not the case is adjudicated delinquent or not. Here, with this court's recent clarification in JF, paragraph 1 of 100C entitles criminal court non-convictions, not guilties, no probable cause, and no bill, to immediate automatic sealing. So that is, again, another protection that would be available to youthful offender proceedings should it fall under 100A. Should it fall on 100B, I think, again, it's less clear. I may be back before you, determining whether or not it would have to wait that time period under 100B. So because as we started this conversation with the fact that it is not mentioned anywhere, we really don't know how to treat them and where to put them. So we have to look at that best analogy, which is that the clerk's records are treated like adult criminal records. If there's no further questions from the court, I'd just like to remind the court that MPS recognizes that the sealing of records serves our mission to support individuals and families in achieving long-term positive change. As such, again, we welcome this court's guidance on the interpretation of the statutes.